first one is Don Siegelman, and the second one is Congressman Gerald Nadler, who's the head of the subcommittee on civil rights for the Department of, supervises the Department of Justice civil rights issues. So we're going to start with Governor Don Siegelman. Welcome to the show.
Hey, thanks so much. I'm also delighted that you're going to have my friend Gerald Nadler. Gerald Nadler has been on the Judiciary Committee, I think, as long or maybe even longer than Chairman John Conyers. And, of course, John Conyers has been a member of Congress more longer than any other living congressman now. I think he's been in Congress for 50 years. But those two guys are smart and tough. And I can tell you, Gerald Nadler is a brilliant constitutional lawyer and is willing to hold the Department of Justice's feet to the fire to ensure that that Americans' civil rights are not violated. And I can start off. I'd like to start off by posing a question to Gerald Nadler that you can pass along to me. But how is it that President Obama, and listen, I'm a supporter of President Obama. I'm not running him down, but President Obama ran for office on change we can believe in. And his lawyers representing President Obama in January of 2010, this is almost a year after he took office, argued to the United States Supreme Court that United States citizens do not have a constitutional right not to be framed. That is, prosecutors can knowingly frame innocent people and not be sued, not be held liable. This was in a case in Iowa where two men had been wrongfully accused by local police and prosecutors and put in prison for over 25 years before they were exonerated. And then President Obama's lawyers come in and argue that they don't have the right to sue the prosecutors or the investigators of the police who knowingly presented false evidence to the jury, because they're afraid that by giving up this civil immunity to prosecutors, that prosecutors wouldn't pursue cases as hard if they knew they could be sued for presenting false evidence. Well, my question to Congressman Nadler is, why shouldn't they be sued? Why shouldn't the government be held responsible for putting these two men in prison for 25 years, knowing that they were being framed? And so that's my question for Congressman Nadler. But I wanted to take just a minute, if I could, to explain to your listeners who I am and why I'm on your show today.
Thank you. That's what I was going to ask. Go ahead, go for it.
Well, yeah, I was the sitting governor of Alabama. I had been elected Secretary of State, Attorney General, Lieutenant Governor, and Governor in a Republican state. In fact, I beat an incumbent Republican governor to become governor in 1998. For a number of years, I had been doing battle with Karl Rove and his buddies, his close friends here in Alabama. And I should note that Karl Rove, after the 1992 campaign, brought his closest friend and business associate to Alabama, and they started working on political campaigns in Alabama in 1992. This was after they lost the Bush-Quayle race against Clinton. And they both, Karl Rove and his close friend Bill Canary, married girls from Alabama. Karl Rove settled on the Gulf Coast at a place called Rosemary Beach, where he still has his $1 million plus home today. I did battle with him in 1994 and 1998 and 1999 and 2000 and 2002. I was investigated immediately after I won the governor's race by Karl Rove's client, who was then the Attorney General of Alabama. I was brought to trial 1 month before the Democratic primary for my re-election campaign by the wife of Karl Rove's best friend, who was the United States Attorney. I should note that Karl Rove's best friend, whose wife was the U.S. attorney, was also the campaign manager for my Republican opponent. So my Republican opponent's campaign manager's wife brought me to trial 1 month before the Democratic primary. I don't think your listeners have to be clairvoyant to connect the dots here. Politics was written all over this case, and that's why I thought this thing was a joke. And I was going to win the case and win the race. It didn't deter me from going out and campaigning, but the end result was that the prosecution, according to 60 Minutes, convinced a felon, a crook as they called him, to rewrite his testimony until he got it the way the government wanted it, and then they presented this false testimony to get a conviction. Very similar to the case that was before the U.S. Supreme Court, where President Obama's lawyers argued that we have no constitutional right not to be framed. I want to drop back.
But wait. Let me just ask a couple questions, okay? Now, the wife of Karl Rove's best friend, who was the wife of the campaign manager of your Republican opponent, that's Leura Canary, right?
Correct. She was the U.S. attorney that brought me to trial 1 month before the Democratic primary election.
And she was the U.S. attorney. That's from the Department of Justice. I just want to tie this together. This was not an Alabama attorney. This was somebody who was appointed to the DOJ by Bush.
By Bush, yeah. Recommended by Karl Rove and approved by President Bush to be the U.S. attorney in Montgomery, Alabama. And by the way, President Obama has not removed her yet. He has not appointed her.
That was my next question. This is, you see, I've got an agenda here too. I want you to tell your story, but I am outraged that Obama has allowed to stay in their job positions these attorneys who were appointed by Bush, supervised and directed by Rove. What do you think of that?
Well, I think it's nuts. I mean, first of all, the American people expect when a president of a different party is elected, they expect the president to put his own people into office, because otherwise he would never get the kind of change that he promised during the election. And of course, we're not getting any kind of change in the Department of Justice. That's why we have these arguments being made that we're not entitled to constitutional protection not to be framed. If he would appoint people who shared his vision of change, if the president would ensure that people who shared his vision were appointed to public office, then he would be accomplishing a lot more and things would be changing. But the Department of Justice basically is, with all due respect to Eric Holder, he's turned over the department to David Margolis, who's been there longer than anybody else, knows every trick in the book, and was part of the cozied up with Bush and Karl Rove's assistants, Monica Goodling and others, and participated in the firing of these Republican U.S. attorneys who would not prosecute Democrats. He participated in the decision to prosecute me. He has participated in the decision to protect Leura Canary. We complained to the Department of Justice that this woman should resign or recuse herself because she was married to Karl Rove's best friend, and her husband was running my opponent's campaign. Well, David Margolis should have removed her and seen to it that she had nothing to do with my case. But that is not what happened. She has remained involved and is the U.S. attorney in Montgomery today.
All right, we're going to be talking more about David Margolis in just a moment. This is the Rob Kall Bottom Up Radio Show, WNJC, 1360. Sponsored by opednews.com. That's OPEDNEWS.com, where you're going to find progressive news and opinion that you're not going to find anywhere else. Op-Ed News is one of the top 100 blogs in the world, according to Technorati. And we've been ranked number 7 as among the top political news sites. So I'm speaking with Governor Don Siegelman, and we're talking about the Department of Justice, and in particular, David Margolis. And this is a guy who a couple years ago was described on the liberal website Daily Kos as the salt of the earth. Now, last week we broadcast an interview with Scott Horton. Did you get a chance to hear that?
I have not, but I have read parts of what Scott said.
And, well, basically, Scott Horton said this guy is really bad news. He's bad news for justice. He's bad news for the Department of Justice. And he has taken it to a low that we have not seen in over a generation. What's your take on this Margolis guy? What do you know about him? Now, people say he's nonpartisan. Is he nonpartisan?
Well, here's my take on it. I think he was a very good prosecutor when he was a U.S. attorney in Connecticut, I believe. And I'm sure he performed some very important functions at the Department of Justice, and most of which probably was performed as a bureaucrat and somebody who was nonpartisan. But the problem that we have today is that because he has been at the top for so long, and because all important decisions have been made by him, including, in my case, my prosecution, the fact that my U.S. attorney had a conflict but was not forced to recuse herself, because he was involved in the firing of U.S. attorneys who wouldn't prosecute Democrats, because he was involved in the hiring of U.S. attorneys who took their places, because, as Scott indicated, he has had some involvement in approving the exercise of torture for interrogation. That means that when these questions come back to him as to was Siegelman's case handled fairly, well, he's got to say yes, because otherwise it incriminates him, because he's the one who made the decision to go after him in the first place. Is he going to
He's the one who made the decision to go after you in the first place?
Yeah, I mean, he's the one that gave approval. He's the one who gave approval under the Bush administration for them to pursue me through the Department of Justice. Back to whether he was directly connected with Karl Rove or whether he got word from somebody else, or my point is that as long as he is making decisions about my case, I'm never going to get a fair shake, because he was involved at the outset in the early decisions that impacted my case going forward. And I think Scott Horton's position is, he should not be the one to make a decision about whether or not the lawyers who approved and rewrote their memorandums approving torture as a means of interrogation. He should not be allowed to review those decisions for prosecutorial purposes, because he was involved in those decisions to begin with. So there's a conflict there. And the problem is that Eric Holder believes in this guy and trusts this guy because he's worked with him in the past. But, for those of us who have been paying attention to what's been going on in the Department of Justice and have a close connection with it, we see that there is a conflict, or what appears to be a conflict of interest, and so therefore David Margolis really shouldn't be making these decisions anymore.
He's 70 years old. Aren't there retirement requirements with the government?
I don't know how old he is, and I have no idea about his retirement requirements. But it's not the age, it's the conflict of interest that bothers me, and I just feel like that, with all due respect to Eric Holder and David Margolis, he needs to step down and step aside from decisions that he was involved in during the last several years during the Bush administration.
Well, last week when I ran my show with Scott Horton and Jesselyn Radak, another person who's been violated by the Department of Justice under Margolis, it came out that Margolis is called the consigliere of the DOJ, the fixer, the cleanup guy. And that's what he does there, is he protects the attorneys. And I've kind of taken this on. I really believe that this guy is a disaster in full power and making things worse and worse there, and we need to get rid of this guy. And if Holder is backing him up, then Holder's making a big mistake. Frankly, I am not so kind to Holder. He has left Leura Canary in, other attorneys that were appointed by Bush who are strictly political. The fact that they're still there a day after Holder was in office is shameful, and as far as I'm concerned, Holder is on the way to becoming what could be the worst Attorney General in our history, maybe even worse than Gonzales.
Well, I will point out, too, that Chairman John Conyers and the House Judiciary Committee, including Gerald Nadler, did a study of selective prosecution under the Bush administration, the Bush administration's Department of Justice, and of course they have linked Karl Rove to those selective prosecutions and to the firing of the U.S. attorneys. There was a lot of information that John Conyers turned over to Alberto Gonzales and Michael McCasey, and subsequently to Eric Holder. I'm only one small piece of this puzzle, but I was included as the number one case under selective prosecution that the House Judiciary Committee made reference to in their report to Eric Holder. But as of this day, 2 years after CBS 60 Minutes did an expose showing where the government abused their power in their prosecution of me, and 2 years after Time Magazine wrote an expose of how I was selectively prosecuted, not one witness has been interviewed, and in fact the whistleblower, one whistleblower, DOJ whistleblower, who came forward and made accusations against Karl Rove's best friend's wife, the U.S. Attorney, Leura Canary, she was fired, and guess who fired her? David Margolis. David Margolis approved of the firing of the whistleblower who wanted to come forward and give testimony that would have incriminated the DOJ lawyer in Montgomery, Alabama.
Now that's Tamara Grimes.
That's right. Tamara Grimes was the DOJ whistleblower who was fired from her job, and her firing was ultimately approved by David Margolis. Everything rises, goes through him, and so that's why, it is impossible for me to get a fair hearing in the Department of Justice while we have this current leadership there. And I'd say this, and I'm not as critical of President Obama as others. I'm just saying that, he's getting hurt because the people around him are not protecting his back, in the sense that they either don't share his vision of change, or don't, well, I think they don't share his vision of change. I mean, that's the only answer I can give. I mean, because otherwise they would be trying to change things that have bothered people that gave rise to President Barack Obama's election as President of the United States.
Now, this is no small consequence to you. This is not a theoretical issue about justice in America. Your life is on the line here, isn't it?
Well, yeah, and let me just say something to your listeners, because they're probably wondering what I was convicted of. I reappointed a CEO to a board to which he had been appointed by 2 Republican governors before I got in. So this guy had actually been appointed by 3 previous governors, 1 Democrat, 2 Republicans. But when I reappointed him to the board, because he had made a contribution to an education lottery campaign, I was trying to create an education lottery in Alabama so our kids in high school, when they finished, could go to college for free. Well, they accused me of bribery, of accepting a bribe, even though they did not accuse me of profiting 1 single penny. They didn't accuse me of taking any money. They just said that I accepted this campaign contribution to the Education Lottery Foundation from the CEO, who was then subsequently reappointed to the same board that he had served on for 12 years under 3 previous governors. I do want to make a note here for your listeners. While I was supporting the lottery to give free college education to Alabama high school seniors, Jack Abramoff, Karl Rove's bagman, who was bilking millions of dollars from Indian casino owners, was pouring millions of dollars into an effort to defeat me in 1998 and to defeat my lottery proposal in 1999 and to defeat me again when I ran for re-election in 2002. John McCain, United States Senator John McCain, did a study of where the money, he traced the money from Abramoff and found that some $15 million came to Alabama to defeat me, ostensibly so the casino interest in neighboring states, Mississippi and Louisiana, would be protected because we wouldn't have a lottery over in Alabama, and therefore people would continue to go to Mississippi and spend their money on the casinos. In 2002, when I ran for re-election, I was declared the winner the night of the election. CBS, ABC, CNN, all the major networks said that I had won the election. Well, after midnight, after the polls closed and the lights went off in a South Alabama County courthouse, the lights in the basement of the sheriff's office came on, and they recounted the votes electronically and claimed that there was a computer glitch and actually shifted 5,000 votes from my column to my Republican opponent's column. Now, keep in mind that Karl Rove's best friend is managing this guy's campaign. So they declare Karl Rove's candidate as the winner, and we asked for a recount, didn't get it. Ended up decided to walk away and come back and run for re-election in 2006. But the 2 people who either claimed credit or who received credit for stealing that election from me was, 1, Karl Rove's partner, who was working in Alabama at the time, and the second person was a guy named Dan Gans, who went to work immediately for a Tom DeLay, Jack Abramoff-related lobbying firm called the Alexandria Strategy Group. Just thought I'd add that as a tidbit for your viewers.
What was his name again?
His name was Dan Gans. Dan Gans was his name, and Karl Rove's partner was a woman named Kitty McCullough, who changed her name to Kelly Kimbrough. Later, she had gotten divorced and gotten remarried and changed both her first and last name, which I thought was odd. But anyway, went from Kitty McCullough to Kelly Kimbrough. But she was the one who was given credit by the state Republican Party, and the other guy, Dan Gans, claimed credit for it, and for discovering this computer glitch. But it was a stolen election. There was no other explanation. Political science professors who've looked at it and studied it and wrote about it have all declared that there was no other explanation, that the votes
Unbelievable. And now we have ESI controlling the majority of electronic voting machines in the country. Were they ESI machines or Diebold machines?
It was the latter. Not
Diebold?
No, it was not Diebold. It was
ESI.
Yeah, I'm pretty sure it was. It was, yeah. But it's a. I want to say this to you for those who are still listening. This is not about. Yes, it is about my freedom. Yeah, and it is about bringing justice to my case. But this is also about justice in the United States, because if they can put me in prison for 7 years for reappointing a Republican, actually, to a board on which he was originally appointed by a Republican governor and reappointed subsequently by 2 other governors, where there was no allegation that I took a single penny. They can do this to anybody in the country. They can do it to you or your family or anybody's family in America.
Well, the fact is, John McTiernan, we had lunch with him this August. He and his associate put together a documentary showing that, in fact, the Bush-appointed Rove supervised Department of Justice basically did this to hundreds of people, threatening families and children and spouses of people they were trying to influence, and jailing people.
I think it was an orchestrated effort by Karl Rove to knock out progressive Democrats across the country, and it didn't have to be governors. It were, in some cases, it was state senators who were looking at running for Congress, or local mayors who were getting ready to run for Congress, speakers of the House who had powerful positions, and they made a determined effort to lower the boom on any Democrat. And of course, if you looked at the studies that have been done of the comparison of, it was like 7-1 Democrats were prosecuted over Republicans, and there was no semblance, or even there was no effort to even appear to be fair about this. And in my case, there was enough prosecutorial evidence to sink a battleship, but yet the only person whose case has been seriously looked at was Senator Ted Stevens, a Republican senator from Alaska, and that was because, frankly, I think there were a lot of Republican senators still in Washington who said, if you want us to play ball with you, you better take a look at Ted Stevens' case. And I'm not faulting Eric Holder for doing that. I just think that that he needs to look at these other cases as well, and examine and go behind these cases and talk to these people and find out why they offered this false testimony. And I think that if due diligence is done, if a real investigation is conducted, they're going to find that Karl Rove's fingerprints are all over the abuse of power of the members of the Department of Justice.
Okay, now we need to take a break here for station ID. This is the Rob Kall Bottom-Up Radio Show, WNJC 1360. I've been speaking with Governor Don Siegelman. We're going to shift over now. The rest of this interview is going to go to podcast, and we're going to continue the show on the radio with my next guest, Congressman Gerald Nadler. Okay, so Don,
yes. I can stay about another 10 minutes if that's okay.
That'd be great. Do you think David Margolis had anything to do with Ted Stevens?
I am sure he did. I don't know to what extent, but I'm sure he was involved in that decision, because it was a decision made at the highest levels of the Department of Justice.
What's the current status?
Again, I don't fault them for what they did in that case at all, because the judge up there, Judge Sullivan, was outraged by the behavior of William Welch and others at the Department of Justice. Well, William Welch was all over my case. He came to Alabama to campaign for, not literally, but hold press conferences and speak out in favor of the prosecution in my case. The problem is with regard to my case is that David Margolis was involved in the charging decision, and he was involved with Tamara Grimes, and he was involved with the U.S. attorney who prosecuted me. So he really doesn't need to be involved in anything that has to do with my exoneration.
Well, who's this guy Welch? Tell me a little bit more about him.
William Welch took the place of Noel Hillman, who was head of the Public Integrity Section of the Department of Justice, and it's in that section where decisions are made to prosecute public officials. But it then goes, it then is signed off on by David Margolis. Margolis is the one who was involved in virtually all of these political prosecutions.
I heard he was involved with the Scooter Libby one, too.
I'm sure he was, just because of the high-profile nature of that case. I was also...
So what's the status... Go ahead.
No, I was also disappointed that when Jack Abramoff was, when they were beginning to peel the onion on Jack Abramoff, and when they were, getting close to getting some real truth out of him, they entered a guilty plea and basically stopped him from talking. That Jack Abramoff has a lot more to tell if anybody was really interested in getting at the truth, both in my case and I suspect in other matters as well.
And you're saying that Margolis did that?
Well, I don't know. I suspect he was involved in that decision because, again, it was a high-profile case, and it's my understanding for the last 15 years or more he has been involved in all of those decisions.
Anything that's high-profile? Is that what you're saying? Anything high-profile he's going to be involved in?
Well, that is my understanding, yes, particularly high-profile political cases. And, of course, Jack Abramoff was both high-profile and political because of his connection to Karl Rove and the Bush administration, and to other congressmen as well, and senators. Well, I'm going to have to sign off, but please give Gerald Nadler my best. He is one of my heroes. He is a mutual friend and someone that I worked with years ago, Alec Lowenstein, who was a member of Congress from Long Island. And Gerald Nadler is a great constitutional lawyer, a gentleman, and someone who will fight hard for justice in this country.
Let me just finish up one last thing. What's your current status on your case?
My case is before the U.S. Supreme Court. It will be a decision will be made by the justices sometime this May or October as to whether or not they will choose to hear my case. If they choose to hear it, it will be heard most probably next spring, about this time. And from there, we will, hopefully get some resolution.
And if they don't choose to hear it?
Then I'll go back to the swamps of Louisiana.
And jail?
Yeah, I would go back for resentencing before the federal judge in Birmingham who had me handcuffed, shackled, and yanked out of the courtroom and put in solitary confinement in a maximum security prison. So all of that for trying to get free college education for Alabama school children, without the accusation, I might say again, that I took a single penny. No allegation was made by the government that I took a single penny. None.
One last thing. You mentioned that there was some witness that they tweaked his testimony. What did they get him to say?
Well, the government wanted to try to establish that the person I appointed or reappointed to this board had brought a check to my office and had personally handed me a check for $250,000. The problem was this guy said the felon originally testified that it was written by somebody else on a different date, and on a date that was impossible because it was the check that we actually got, the one he was referring to, was signed by somebody else and was on a different date. So the government was trying to get this guy to lie, and he did lie in order to secure a conviction. Scott Pelley of CBS 60 Minutes said, I believe, couldn't have happened that way, and I think that was his quote, because the check wasn't even written at the time the government said, or the government got this guy to say it was written.
Okay.
We've got a long way to go, but I want to applaud you and this program, as well as Congressman Nadler and John Conyers, one of my heroes, for continuing the fight for justice in this country and around the world. This case is important because all roads lead to Rove, and this case will take us there in the shortest time possible. That's why it's important that this case be investigated fully. Secondly, it is important that John Conyers and Gerald Nadler continue their hearings on torture so that we can get to the bottom of who ordered those memos to be changed, and whether or not Karl Rove was involved in that decision as well. I think it's important for us to continue to pursue when Karl Rove knew that the allegations of weapons of mass destruction in Iraq was not true, whether they used that as a guise just to create a war so they could win midterm elections. I think there are a lot of unanswered questions that would help bring closure and would help reestablish justice and secure our democracy if they are properly investigated.
Do you think that Rove will ever face justice?
It depends on President Obama and what he wants to look forward, not backward. He says, and that seems to me to be. I'm not going to investigate Karl Rove. I'm not going to investigate torture. I'm not going to investigate the elections that were stolen. I'm not going to investigate people who were put in prison falsely. But that does not explain. If you're looking forward, not backward, why would he let his lawyers argue to the U.S. Supreme Court this January that American citizens don't have a constitutional right not to be framed by U.S. prosecutors? I've got to go. I appreciate your call. Thank you so much.
Thank you so much. See you.
All right, bye-bye.
One, this is the Rob Call, Bottom Up Radio Show, WNJC 1360, and I'm speaking with Congressman Gerald Nadler. Welcome to the show.
Hi.
Hi.
Good to be here.
The other half of this show is an interview with Governor Don Siegelman, and he gives his regards, says wonderful, glowing things about you.
Well, I wish him best of luck. I think he's been the object of a really foul play.
I agree. Yet, here we are. We have a Department of Justice run by an Obama appointee, and it doesn't seem like it's changed anything.
Well, I think we all have been very disappointed in the administration in its conduct of the Department of Justice in any number of ways. They have changed some things. They certainly certainly, well, let's put it this way. They have completely revamped and are healing the Civil Rights Division. Civil rights questions, after 8 years of the Department of Justice trashing the civil rights laws, trashing the Voting Rights Act, not enforcing it, and so forth, it's being changed completely. The Voting Rights Act, remember how they had completely gotten rid of career professionals, career attorneys at the Voting Rights Division, how they put in right-wing ideologues and so forth. That's all changed. They're reprofessionalizing the Civil Rights Division. They're looking to enforce the Civil Rights and the Voting Rights Act again. That I have unstinting praise for. Civil liberties, unfortunately, is a very different question.
Yes, we do have that little problem with John Yoo and Jay Bybee that was created by David Margolis.
But that's not the only problem.
Okay,
but that's not even the heart of that problem. That's not even the heart of that problem. Because the Attorney General decided earlier on, and announced it several months ago, that they would not appoint a special prosecutor. They would not seek to prosecute or even to investigate anyone for the torture. They said that remember, we are signatories to the Convention Against Torture. We have the Anti-Torture Act, which was signed into law in the 1990s, and both the treaty and the law, and the treaty, of course, is the law of the land, but we passed our own law, say the same thing. There is no excuse for torture. State necessity, war, etc. No excuse. Number one. Number two, where there is any kind of credible allegation that torture may have occurred, there must be an investigation, and if the evidence warrants it, prosecution. Okay, we know there was torture. The former Vice President, Mr. Cheney, says, I ordered waterboarding. The Attorney General says waterboarding is torture. So we know there was torture. We know it was ordered by the Attorney General, by the former Vice President. He said it himself. We know that you and Bybee wrote memos authorizing torture. Certainly, all this, we are duty-bound by law to investigate this, to investigate anyone who authorized torture, because you can't just go after the lower guys. Now, it may be that their justification will hold. It might be that after investigating, you decide you couldn't get a conviction, therefore you don't initiate a prosecution. But certainly there's got to be at least an investigation with an eye toward prosecution. And since the Justice Department was involved in all this, through you and Bybee and so forth, it's an inherent conflict of interest, as Mr. Margolis has just shown, for the department to investigate itself, even under a change of administration, and therefore there must be, under law, a special prosecutor. I wrote to the Attorney General along these lines, and they have refused to do this.
So what can the House Judiciary Committee do about this? You're a chair of the subcommittee. Is there anything that can be done?
Well, unfortunately, we cannot order. We can only point out the law. We cannot order the department to the Attorney General, rather, to appoint a special prosecutor. We've urged that. I've urged that in every way we could, and they've basically given us non-committal replies. Now, the Attorney General said that they might investigate and prosecute instances of torture that either predated the you and Bybee memos or went even beyond what they authorized, the so-called rogue thing. And that's nice, but that only means that some low-level person who went really crazy might be prosecuted. Now, on the you and Bybee, Mr. Margolis decided to overrule the Office of Legal Counsel and decided to overrule the Office of Legal Counsel and not to refer that ruling to the bar associations, because the OLC had decided that had ruled that you and Bybee's memos not only were wrong, but were abuses of power and were violations of the ethical rules of the bar. Margolis decided that he would overrule that, and the Justice Department wouldn't refer these to the bar associations. So I took it upon myself. I took their reports, and I referred it to the bar associations. I sent it to the bar associations. Obviously, that'll have a lot less impact than had the Justice Department referred to the bar associations, but we could do that, and I did that.
Any response there?
No, that just happened about a week ago.
Okay.
Week or two
well,
ago.
Thank you for doing that. What do you know about Margolis? Because a couple of years ago, people were characterizing him as salt of the earth, and it sure looks different now.
He seems to be, from what I can tell, and I don't know much about him, but he does not seem to be an apologist for torture or anything, but he does seem to be an institutional loyalist to the Justice Department. And that's why I said that you have to have a special prosecutor, because even with a change in administrations, the Justice Department is not dispassionate in deciding whether to investigate itself or former officials of itself. It's
well,
a conflict of interest.
I've kind of started. I've gotten very interested in this Margolis, and others have too. Don Siegelman tells me that he signed off on appointing and approving Leura Canary to investigate him on that trumped-up charge. Scott Horton says that he's been involved in many of these problematic prosecutorial misconduct cases that are going on. Is there any chance that your committee can investigate this guy and check him out further? It seems like just
we don't investigate individuals. We might investigate, or rather inquire into a pattern of conduct if there is something happening that the Justice Department isn't doing right, and if there's a pattern that you can show, then we'd have to take a look at that. But it's not our job.
Isn't that what you just talked about?
Well, I said one instance. I think he was wrong in what he did. You mentioned other instances that I don't know anything about. Other instances where he did allegedly wrong things on other subjects. What I was saying was that, that may be. But what I was saying is that the very fact that he made this decision is a good illustration of why you need an independent prosecutor to look at these decisions, because there's an inherent conflict when you're dealing with your own department.
How does that happen? How does an independent
In fact, I'll tell you something else. One thing I think we ought to take a look at is in most agencies, reviewing the report by OLC would not have been the job of some superior, but would have been the job of an inspector general. Now, the statute establishing the Inspector General's office in the Department of Justice constrains his authority in a way that isn't constrained in other agencies, and I think we're going to take a look at that and maybe introduce some legislation on that.
That sounds great. Now, another issue that
you asked about the department generally. One is the lack of they're not going after people who tortured, etc., the lack of trying to hold the previous administration accountable. Now, I know that it's not just their fault, it's the president. The president says look forward, not backward. But, of course, if you look forward and not backward, you would never prosecute any crime. And there were crimes clearly committed, and I think that's just wrong. And we established the precedent at Nuremberg, and the precedent that certainly when we judged the German judges and prosecutors for distorting the law. I mean, I think that's an applicable precedent here, when we prosecuted Japanese generals for not stopping waterboarding that they didn't order, but that they didn't stop it. That's a precedent, and we're violating those. Secondly, of course, you have the whole state secrets question, which is probably the worst thing.
Talk about that.
Well, let me put it in context first. If the government, we all have rights. The whole point of the United States is liberty, that we have rights. We have rights of privacy. We have rights of all the First Amendment freedoms, everything else, freedom of whatever. If the government violates your rights, if the government agents, without a warrant, invade your home and ransack your papers, or if you're a conservative, steal your guns, or whatever, or kidnap you, and ship you to Syria to be tortured, or torture you, what is your remedy? There's an old maxim in law that says there's no right without a remedy. If you have a whole list of rights, but there's nothing to do to enforce them, if the government violates them, it doesn't matter, then you don't have the right. So the question is, what is the remedy if the government violates your rights? And when you come right down to it, there's only one real remedy. You can sue the government. And you can sue them for an injunction, which is a way of the court saying, stop what you're doing and don't do it again. Or perhaps, and damages. Stop what you're doing and pay me damages for having ransacked my house last week, or for having tortured me. And that's how you get into court, and you get an order to stop, and you get damages. It's the only way, really, you can enforce the rights. And without that, the Bill of Rights, the laws that we pass aren't worth the paper they're written on. Okay, but what happens if, when you go to court, you sue the government, and you allege that they ransacked your house, or they kidnapped you, or they beat you up, or whatever it is, and the government files an answer to your complaint before any hearing has occurred, before any discovery has occurred? First thing the government does is moves to dismiss the complaint, dismiss the action, get rid of the lawsuit, on the grounds that hearing the lawsuit will necessitate the revelation of state secrets and will thus endanger national security, or moves to dismiss the lawsuit on the grounds that the subject matter of the lawsuit, whether in fact they tortured you, whether in fact they ransacked your home, is itself a state secret. And if they can do that, and the court then dismisses the lawsuit without having but just by accepting the government's statement that you can't hear this case because it would reveal state secrets, then you can never get into court, and you have no rights, and none of us have any rights. And that's what the State Secrets Act is what the State Secrets Doctrine is being used at. Now, this doctrine started off as simply a way for the government to say you can't see that document in court because that document would show a state secret. Now, under Bush, it changed into you can't have the lawsuit to start with. And Obama is going right along with that, unfortunately. Now, I introduced legislation in the House, and Senator Kennedy and Senator Specter and Senator Leahy introduced similar legislation in the Senate that said two things. One, we call it the State Secrets Reform Act. One, you can't move to dismiss a case under by use of the State Secret Doctrine. You can't simply say, don't hear the case. You can move to suppress evidence. You can't see that document. And it's conceivable that if the court agrees that all the documents must be suppressed, that the case collapses. But you can't move to dismiss the case. Point one. Point two, if the government moves to suppress a document, you can't see that affidavit or whatever, or some piece of evidence, the judge must hold a hearing on whether to suppress the evidence, a suppression hearing, behind closed doors, in camera. The judge can appoint security-cleared lawyers on both sides. He can appoint a security-cleared magistrate if he wants. But there must be a suppression hearing. And in that hearing, the government has to convince the judge that it is in fact a vitally important secret that would endanger national security would be revealed if that piece of evidence was used. And the judge has to agree to that. If the judge doesn't agree to that, that evidence gets admitted. And of course, the federal government rather can appeal that decision, but the courts ultimately decide whether the evidence can be admitted. And if the courts decide the evidence cannot be admitted, then the court tries to find a way of a summary of the evidence or redacted version of the evidence. But you make every attempt to get the evidence admitted, and more to the point, the courts, not the executive branch, decides. You cannot have the executive branch deciding that you're guilty and that it will withhold evidence, all evidence that shows you're not, or deciding that they're entitled to invade your home or torture you and withhold all evidence showing that they're not. The executive branch, to quote the Ninth Circuit Court of Appeals, cannot be its own judge. That's fundamental to American liberty. If we allow the executive branch, whether it's Obama or Bush or the next guy, to get away with this use of the State Secrets Doctrine, there is no protection left for American liberty. Now, the courts, some courts have let them get away with it. Some courts have essentially said that my bill is the way to go and ordered those procedures through court order, and the Obama administration has insisted on appealing them. And it's still pending before the courts. And they are, of course, not supporting the bill. In fact, they've made it clear behind the scenes that they're opposing the bill.
Just like Bush would.
Yes, with the same orders. In fact, there was a hearing in one of the key cases, and they have used the State Secrets Act to prevent anybody alleging that they were tortured, or that they were the victim of rendition, or that they were the victim of warrantless wiretapping. They've used this to prevent getting into court and challenging those actions by the Bush administration. Now, one of the leading cases, the Jefferson case, in which a number of people alleged that they were, in effect, kidnapped and shipped by the government to various countries in North Africa, in the Middle East, to be tortured. They sued the airline company, Jefferson Data Plan, is a subsidiary of Boeing, which allegedly contracted with the CIA to ferry people to be tortured. So they sued this company. The government moved to dismiss the case on the grounds of the state secrets doctrine. The case was argued in the Ninth Circuit Court in front of a panel of 3 judges of the Court of Appeals in the fall of 2008. In December of 2008, the court ordered re-argument in February of 2009. Why re-argument? Normally, if the court orders re-argument, it says, by the way, brief the following subjects that no one discussed. We're interested in the following questions. They didn't do that. They simply ordered re-argument with no explanation. The only explanation people could think of is that they wanted to see the new administration explain its position in court rather than just the old one. When the case came into court and was re-argued in February in front of the Ninth Circuit Court of Appeals panel, one of the judges looked at the attorney for the government and said, "Counselor, do you mean to tell me that the passage of time has not altered the position of the department in this matter?" He said, "Yes, Your Honor." One of the other judges was so startled that he interrupted and said, "Counselor, do you mean to tell me that the change of administrations has not altered the position of the department in this matter?" And he said, "Yes, Your Honor, this has been vetted at the highest levels of the department." So the Obama administration has gone right down the line, at least on the question of state secrets and some of the other key civil liberties questions with the Bush administration. They haven't said the same things publicly, but where counted in court, they've just done the same. They've done exactly the same thing.
Can you speculate on who in the Obama administration would be making these calls?
I don't know. I've seen speculation that, well, making the call, I don't know. I mean, it could be the Attorney General. It could be someone in the White House. I've seen speculation that Greg Craig, the former White House counsel, left because he didn't want to go along with some of these things, but I really don't know.
You know, Don Siegelman asked me to ask you, there was recently a decision that the Obama government fought for that basically defends prosecutors for presenting false evidence, that they don't give up civil immunity.
Defends prosecutors for knowingly using false evidence?
Yes, this is what Don said. He mentions it because he feels he's experienced something similar to this.
Well, prosecutors who knowingly use, and the key is knowingly, but any attorney who knowingly uses false evidence ought to be disbarred. I don't care if it's the U.S. attorney or the defense attorney. If he knowingly...
Don says that Obama's team sent defenders to stand for the prosecutors who were involved in the case 20 years ago, where they knew that they were presenting evidence.
Well, I hope the defense was that they didn't really know, and that's a question of fact. If the defense was, we concede that they knew it was false evidence, and it's too bad, that's terrible.
It is terrible. You know, the other thing
I'm not familiar with the case, but if that's what happened, it's indefensible. I hope what happened in this case, whichever case, I don't know the name of whatever case it was that they contested whether the prosecutors knew. What?
Want me to get you the information?
Yeah, I'd be interested after this radio show, yes.
Yeah, I'll get it to you. I'll get it from Governor Siegelman.
It's inconceivable to me that a court would agree that a prosecutor who knowingly used false information should not be disciplined in some way.
It might have been inconceivable to you that
Now, there's a different question. There's a different question, by the way, which I could see this Supreme Court doing the wrong thing on. And that is, let's assume that you showed that the prosecutor knowingly used false information. Certainly you should discipline the prosecutor, but the other question that comes up is, well, do you overturn the conviction? And assuming there was a conviction. And I wouldn't be shocked if this Supreme Court said, not necessarily, because it may have been harmless error, and you have to show, in order to overthrow the conviction, that but for this evidence, the jury would certainly have acquitted, raising a very high bar. That I could see this Supreme Court, not a good Supreme Court, but this Supreme Court I could see saying that.
this Supreme Court is definitely not a good Supreme Court, at least the five that are...
A good, self-respecting court would not count in such an argument, but this Supreme Court might.
Now, I need to follow a little bit more back to the DOJ. There are still Bush appointees, political appointees, holding jobs there. Isn't there something wrong with that?
Well, politically, yes. Well, I think I don't know to what extent that's because the Obama people haven't made appointments, and to what extent it's because the Senate. I mean, we know that the Senate is dragging its feet, and the Republicans are filibustering every nomination. I mean, the Don Johnson, who would be a very good person as the head of the OLC, Office of Legal Counsel, is still waiting Senate confirmation after a year. So, to some extent, that may very well be because, maybe to the major extent, that the Senate, the Republicans in the Senate obstructing a lot of nominations, which they certainly have for the Justice Department.
Well, the way Bush dealt with that was he used interim, more temporary appointments.
Well, and the president may have to do that, and I certainly hope he does if necessary.
Yeah.
And certainly in some of these things, they're necessary. Don Johnson, I mean, to have that position still vacant when you're trying to clean up the Justice Department and reconstruct it is inexcusable.
There's a lot that's inexcusable that's going on, and I think that's got to get cleaned up pretty soon, before November. What are your big projects you're working on now?
Well, I'm working on a number of projects. The State Secrets Bill is probably the most important one in the judiciary. The Iqbal Bill, are you familiar with the Iqbal decision? This was a very important decision that didn't get enough publicity. For 50 years prior to the Supreme Court decision, if you when you went into court, you sued General Motors for dumping toxic waste in the water, let's say, and thereby causing damage. All you alleged in your pleading is that you had reason to believe that they did this, and this is terribly harmful. They moved to dismiss the case, and the court would deny the motion to dismiss if it found that, assuming the total truth of everything you said, that there's still no legal claim. But for that purpose, it would have to assume the truth of everything you alleged, because otherwise, make you introduce evidence. And of course, you would then go and get discovery, because many wrongdoers, especially tortfeasors, people who are throwing crud in the river or the air or whatever, they have more evidence than the complainant does at the beginning. They've got all the records. Sure. And so for 50 years, that was the standard. It's called notice pleading. And the purpose of pleading was simply to give notice to the defendant what you're trying to prove and what the charge is. And as long as you stated the charge, and as long as the charge was sufficient so that, assuming the truthfulness of everything you stated, there was a cause of action, they would not grant the motion to dismiss at the beginning of the case. In the Iqbal decision, they said no, the judge should grant a motion to dismiss right up front if he didn't think you had made a plausible case. So this becomes a great obstacle to getting into court, because judges may very well not think you've made a plausible case because you haven't shown any evidence yet, because you don't have the evidence until you get discovery, or you don't have enough evidence. And it makes it a balancing test before there's a balance. This is another part of the court's crusade to make it more difficult for people to sue corporations and other wrongdoers. They've narrowed the standing requirements, and this is another one that it's been cited just in a few months since it was decided, in 1,500 court dismissals of cases all across the country. It will make it very difficult, almost impossible, for individuals or community groups to sue big corporations. And I've introduced legislation to go back to the notice pleading that we've had for 50 years, which has worked very well. That's another major thing we're working on. We've got a number of other things. I'd like to try to get accountability, and then I'm working on a lot of things other than in the Judiciary Committee. Healthcare, obviously. I've been one of the leading proponents of the public option and opponents of the so-called Cadillac tax. I don't think we should be taxing benefits. I've done a lot of work on what we're not supposed to call stimulus, economic stimulus, the Economic Recovery Act, the American Recovery Act. I thought the major problem with it was that it was much too small. We need a lot more government injection of funds to produce aggregate demand to get us out of where we are. I've been very active on trying to get more infrastructure spending and more intelligent infrastructure spending, especially on freight, where freight doesn't vote, so it gets very little proper attention. And these are some of the things I've been working on.
You haven't mentioned the decision that lets corporations spend an unlimited amount of money.
Oh God, yes, that's enough. I've been working on that too. That is perhaps one of the most dangerous decisions ever.
Let me just give a
what I'd really like to do is to
Let me just give a station ID. This is the Rob Kall bottom-up radio show WNJC 1360 with Congressman Gerald Nadler, and we're going to the podcast side now. Go. Tell me about this insane decision to give this gift to corporations.
Well, let's put it this way. What I'd really like to do is get rid of the 1886 decision by the Supreme Court that said corporations are persons under the meaning of the 14th Amendment. It certainly was never the case and shouldn't be the case. But this decision, in the name of, says corporations have the same free speech right as individuals, and therefore most of our laws restraining corporate campaign contributions are unconstitutional. So it now becomes illegal for a lobbyist to sit in my office and say, and buy me a cup of, it's illegal for lobbyists to buy me a cup of coffee. It is perfectly legal under this decision for the same lobbyist to sit in my office and say, Congressman, we have $5 million to run ads saying what a wonderful guy you are or what a terrible guy you are and why they should never vote for you or should always vote for you, depending how you vote on the following amendment or bill. That's legal. It's not bribery. They're just informing me of the fact that if I vote this way, they'll run $5 million of ads saying they should vote for my opponent, and if I vote the other way, they'll run $5 million of ads saying people should vote for me. That's not bribery. It's just a fact, and under this decision, that's legal. It means a great, great step toward corporate control of all our politics. Now, I have said for a long time that the campaign finance system that we live with, and this has made it far, far worse, is a metastasized cancer on the American democratic process. And if we don't fix it, the historians will eventually write of the United States, as they do of the Roman Republic, that we had a very nice 200-year run with democracy, but then it ceased to be a democracy. It became an oligarchy or a plutocracy or something. Now, the only way to fix it, I'm co-sponsoring legislation that Chuck Schumer and Chris Van Hollen are the lead sponsors on, which can fix this around the edges. It's as far as we can constitutionally go under this decision, and we can certainly say that companies seeking government contracts cannot run ads saying vote for with corporate funds saying vote for or against a candidate for Congress. We can certainly say that corporations that are foreign controlled, and we can define foreign control as X% of the board of directors or the shareholders, cannot use corporate funds for running ads for or against the candidate, and that's what this legislation does. But it's very limited. What we really have to do is get an intelligent court that will change that, or amend the Constitution, which is impossible because you never get 2/3 in both houses. Although maybe we should start a campaign to do that, and eventually we have to have a really strong publicly financed campaign system, or this country will be a democracy in name only after a while.
That 1886 ruling that you referred to, Tom Hartman wrote about that, and that it was really a decision that was interpreted by the chief clerk of the Supreme Court.
Well, that's true, but
the railroad CEO.
Yeah, but it is true that the court didn't really say it. The reporter, the chief reporter did, and that was probably improper at the time, but it's irrelevant now because 120 years of Supreme Courts have in effect gone along with that and affirmed that decision.
That 100 and some years of Supreme Court decisions didn't seem to affect the Roberts Court when they made their decision.
Well, listen, as I said, if we got a better Supreme Court, they could overturn it. But but the fact that the 1886 court did not say what the reporter said it said is a historic footnote, because the courts have acted as if it did and have reaffirmed it. If we had a good Supreme Court, it might overturn this whole line of cases, and it should.
Yeah.
I've got to get going now.
2 more minutes to wrap?
2 more minutes, but that's it. I've got to, yeah.
Look, you've given me a lot of time. I really appreciate it. I'm not great on pressure. Could the Supreme Court, if its composition changed, reverse that 1886 ruling too?
Certainly it could. I wish it would.
Okay.
That's a constitutional decision, and they can reverse it.
The last thing I wanted to get with you.
Listen, in 1954, the Supreme Court in Brown versus Board of Education overturned explicitly the 1896 decision in Plessy versus Ferguson. Of course they can.
Good. We're just celebrating the civil rights protests in Selma. Yet legislation has recently been passed that basically turns eco-protesters into eco-terrorists who go to jail for long terms. Where do you stand on this assault upon the tradition?
I'm not familiar with the legislation you're talking about.
I'll get it to you then. This has been great.
When you say recently passed, this year, last year, I don't.
Within the last couple of years, corporations pushed through legislation that basically makes people who protest environmental issues treated as terrorists, literally.
Well, as you described it, all right. As you described it, it's obviously terrible. I'm not familiar with the bill. I'd have to look at it. But your description of it is obviously bad. And not that your description is bad. If it's as you described, it's terrible.
I've got 2 homeworks to send to you. I'll get them both to you. Thank you so much for being on the show. Hope to have you back sometime.
You're quite welcome. Bye-bye.
Okay, bye.